We are here with Cindy Merlis and Greg with Kaliser. Thanks for coming on, guys. So, a lot of times we get questions about what is going on in the legal world right now. So I'm gonna start with just sort of what you guys are seeing on acquisitions right now. Obviously, don't talk about a specific deal, and everything we say is not legal advice. But the on the acquisition front, what are you guys seeing in terms of you guys see a lot of PSAs, a lot of LOIs? What are you seeing out there in the market right now?
We are. I'd say we're seeing, both a lot of LOIs, certainly a lot of people making offers. There's definitely deals to be had now. If people have capital and financing, that's kind of the key. But we are seeing a lot of new PSAs, less money going hard 100% upfront, which is a little bit of a change.
Okay.
Mostly a portion hard upfront and then remainder after due diligence.
Okay.
Maybe more financing contingencies than we've seen, when the market was really a seller's market.
Definitely some extension options in the LOIs, depending on, ability to get financing or just to build that in case financing takes longer than anticipated.
Yeah, financing takes longer or just the equity side of the equation. I mean, what are you guys seeing on equity right now in terms of, raising money? Are most people still doing just your standard 506B, or are we seeing more Cs out there, or what's sort of the mix that you guys are seeing right now?
Kind of a bit of both.
Probably a healthy mix of both. There are some clients that are utilizing sort of the ability where you can do the B and then the C, sort of one after the other without the 6-month wait period that used to be in effect. Certainly that can add some complications to the deal and to legal, but right now it's sort of whatever we can do legally to raise the money.
I wasn't going to go down that road, but can you explain that at a high level? And I'll once again say, please reach out to these guys if you have this question. So you're saying you start with the 506B,
correct,
and then you convert it to a C?
Essentially, you're really doing two offerings at that point. So you terminate
Okay.
the B offering once you're done with the B, and then you can go to the C and basically generally solicit and advertise. Typically you're basically treating the investors the same from a return standpoint, a distribution standpoint, and the PPM is even the same. Some of the the verification requirements are certainly different, those kind of things, but it's much more complicated to go from a C to a B. Those are certainly different requirements because on a C you've already gone out and advertised, which sort of, I don't want to say taints the market, but influences the market that you may have on a 506B.
Got it. All right. So start with the B, so you have at least the option of going to the C, but you can't go backwards, I guess, on it. And then so acquisitions, so a little bit better terms for buyers out there right now, but then for current owners, when current owners are calling you, why are they calling you?
Assuming they're not calling to sell their asset.
Yeah. All right. So they might be calling you to do a PSA, right?
Yeah.
All right. That's usually, hopefully that's good news, right? Everybody's selling at a good number.
Selling at a good number. Yep.
And then, so when are they calling you, and maybe it's not as good news?
Yeah. So I would say that the main things are about getting short-term funding. So sort of exploring options as I see capital calls are an option. Sponsor loans, investor loans can be an option. I'll give the lawyer speak. It's very important if you're exploring those options to discuss with your legal team. Every company agreement is different in terms of abilities for the capital calls and sponsor loans, and then of course your loan documents. A lot of people don't realize that loan documents typically prohibit any sort of subordinate debt, regardless of whether that debt is secured or unsecured, like a typical simple promissory note. So it's really important that you have a good understanding of your corporate structure, of your loan docs, of your company agreement before you go down one of those paths.
Okay. And then, so when people, so on the capital call, majority of that time, that is coming from the LPs versus, and that's going to sort of typically reshake the Exhibit A, I'm guessing, of the LLC.
Yeah,
Yeah.
and it depends on how the company agreement reads. But like for instance, most of our company agreements essentially give the LPs the right to contribute their pro rata share, so that everybody, in a perfect world, everybody contributes their pro rata share, and the ownership doesn't change.
Okay.
That's not really how it often plays out because of course, some people aren't able to contribute, and some people want to contribute more. So ultimately, yeah, it can change the Exhibit A, but technically, at least within our agreements, for most of our agreements, the LPs are supposed to be afforded their right to contribute a pro rata portion.
Okay. And then, so if the org chart does change or the Exhibit A does change, then you need to let the lender know, though.
Yeah, and it certainly depends on how your loan docs read. There are loans where KP must own at least 5% of the company, and you do a capital call, and all of a sudden they own 4.5, and you may be in default without even realizing it. So before you do anything, really, it's important to discuss with your legal team. What are my legitimate options here?
And then how's the sponsor loan different than just the capital call? Just from maybe the GP is comparing the two, like, okay, maybe I loan $1 million to the entity versus like going out and tracking down $5,000 from all these people. I just do the loan myself. What sort of pros and cons are there for the sponsor loan if you're able to do it per your loan docs?
Sure. So the pros are that you're going to one person as opposed to having to go to all your investors who they don't like the term capital call to begin with. Right. So if you're able to avoid that, having to go to them and having to use that term, that's certainly a plus.
Right.
You're getting you're paying a fixed amount presumably in that promissory note, whereas on a typical capital call, you're just it's sort of an unlimited potential return theoretically.
Right.
The downside, like you said, is that your loan docs may very well prohibit you doing that, and you may be putting yourself in a default situation with the lender.
Okay, gotcha. All right. So capital calls are always allowed, but sponsor loans, read the loan agreement.
I would still read the loan agreement for capital calls. Yeah.
Okay. All right. Gotcha. I mean, you guys have been doing this, I feel like, probably longer than I have been doing what I'm doing. But what do you think sort of differentiates you from, other legal firms out there? Obviously, you guys are here in Dallas and you guys sort of work on the entire transaction, but talk to maybe some of the differences between your firm and some of the other firms.
Yeah, well, I think you mentioned an important one, that we are full service, which means we can take clients from contract to closing, including syndications. So not all law firms are both SEC attorneys and transactional attorneys, and we are, which in addition to just the ease of dealing with one firm for our clients, there's so many overlaps in the SEC work and the transactional work that it really helps having one law firm communicate with the lender, communicate with the title company, facilitate the closing, create the LLCs, all the documents. So just feedback from hundreds and hundreds of clients that we've worked with is it's easier. It's also more cost effective, only having to pay one law firm for the transaction. Another
thing too that's pretty unique about us is our actual, our perspective and our actual experience within the real estate business. Merrill has been a GP on what seems like 100 deals at this point. Cindy's been a GP. We've all been LPs. So we not only are able to look at things through the legal lens, we're able to look at things through the business lens, but also just from the business side through the GP and the LP perspective separately as well.
Is there any, probably a lot of people are probably just starting their journey to some extent on what advice would you have for someone who's, I think a lot of times you sort of learn the terms, but then like what advice would you have for someone who's like just getting started? Maybe they're trying to do their first deal in the next 6 months or so. What advice would you have for someone just starting?
I think building their team at the outset, is really helpful so that as they're looking at deals, and if they are fortunate enough to have an LOI accepted, they have a team in place that they've already spoken with, kind of vetted. So, they're ready to go when that happens. else can you think of?
I would say treat your potential partnerships like a potential marriage. We've seen people where they meet on a bus and they talk for 5 minutes and they go into a deal together, and then the deal doesn't go so well. So I would make sure that you're vetting your potential partners and very comfortable and trust those people that you're entering into business with, because in a sense it is a marriage.
Yeah. And also, as they're exploring what they're doing, build connections. Start building their potential base of investors, so they have, if they're going to do a syndication, they have some built-in already contacts to reach out to.
Right. Okay. So I've looked at a lot of PPMs, and they all look pretty much the same to me. But on the operating agreements, this is probably where I've seen the most variation across, like when you're looking at different syndications to invest in and when people are raising money. So do you have any tips on the operating agreement, just so that, I've seen some people spell out like the roles and responsibilities of each person versus just like saying, these 5 guys are going to be managers, and there's almost no way that 5 people can decide on, where to go out to eat tonight. So having them decide on a real estate deal is a little bit harder. Like, what tips do you have on the operating agreement for people out there?
So I guess you're talking about like from a GP perspective.
GP perspective. Yep.
Yeah, so I think the important things are you have a clear way to make major decisions, and you have it to where there's not going to be a deadlock. So you have it, depending on how the ownership breaks down and how many GPs there are, you do it so that hopefully there's not an outcome that can be 50-50, or if there is an outcome that can be 50-50, that you have a clear, objective deadlock or a mechanism to overcome that deadlock. And then in the operating agreement, you sort of define what a major decision is. Selling the asset, firing the property manager, expending company funds over 5,000, things like that are really just business decisions between the GPs, and then that can just easily be documented within the operating agreement.
Okay, I'm gonna go in a little bit different direction here. Within some of these loan agreements, there are, let's say, debt service coverage tests or cash flow sweep tests. Are any GPs reaching out to you to talk about interpretation of that stuff, or does that come up? Hopefully that question made some sense.
It does, and we're actually getting new clients that we did not represent on the origination of the loan come to us and ask us to review their loan docs and sort of interpret what their, particularly as guarantors, their potential liability is. Unfortunately, a lot of those bridge lenders, the way that they run those tests, they basically just say in the lender's sole discretion, and it's no fault of the previous legal team or anything like that. That's just the way those loan docs read, and those bridge lenders aren't real negotiable on points like that. But the way that works is that it gives the lender an extreme amount of flexibility in how they run that test. So yeah, we are getting clients, to answer your question. We are getting clients or new clients reaching out to us sort of for our interpretation. I think the biggest thing is on deals that are a little bit underwater right now, what the potential guarantor liability is.
Okay. Have you seen lenders be flexible in extending or modifying loan agreements? Are people sort of staying put on their loan agreement? Like if the loan agreement says you needed a 125 debt service coverage to extend this loan, are you seeing lenders sort of stay put, or are they being a little bit more flexible on, their definition of debt service coverage and sort of just saying, all right, I don't want the property back. So, let's give you a 12-month extension. Maybe you pay a little bit down on the loan and we just kick the can another year. Have you seen any of that, or is it too early for that?
Yeah, so what I think we've seen the most is lenders are flexible in what they say and what they're willing to actually do. Whether when it comes to modifying the actual loan docs themselves, they're a little bit less flexible because I think they want to, in a sense, preserve their flexibility to exercise rights under those existing loan docs. But I think you said it well. The lenders, for the most part, and absent very few limited circumstances, they do not want to foreclose on these properties right now, especially if the property is worth less than the original loan amount or the outstanding loan amount. That is not what they want to do. So they are being flexible for the most part, working with GPs. Transparency, constant communication with the lender is your best bet for the most part, and that's how we've seen them be most willing to work with borrowers. I think the pref-ec groups are a little bit of a different discussion in terms of how aggressive they want to be going after properties. But again, I think transparency, constant communication, showing them, the lender, that you have a plan, keeping them in the loop in terms of your thought process, your options, why you want to go with one over the other, things like that. You're way more likely to get a lender to be flexible and work with you if you're approaching things that way, as opposed to if you just go radio silent on them and then just show up, with a request or something like that.
Yeah. 2 weeks before the loan maturity, asking for an extension is not going to work. So start the process early. And then you did mention pref equity. Does that, as a GP, does that change any of my documents in terms of PPM, loan agreement, operating agreement? Does that change any of that, or is there usually like all of them? Okay. Well, I guess, how does it change them? I guess, is it just because it's another party to the deal, or?
Yeah. So, and I'll give you a typical lawyer answer. It depends. It depends. I would say the first thing is on the terms that pref-ec is requiring or coming in with. If they're coming in and they have the ability to sort of take over the deal the second you default with them, or 30 days after you default with them, then that's something that's going to have to be pre-approved by the lender. So essentially, the lender is going to have to go through a whole underwriting process with them. They're probably going to want replacement guarantors, things like that. So it really just depends on the specific lender and the specific preferred equity company. But yeah, for the most part, what you're doing is you're essentially bringing in a second lender, even though it's not technically a loan, that they can't foreclose on the property. They can take over typically the entities that own the property. And we have seen them be much more aggressive than traditional mortgage lenders.
Right. Yeah. Because I mean, to some extent, they're trying to protect their equity also, right? So they've put in some money in the deal, and then if the regular equity doesn't pay the loan, then these guys are wiped out too, or could be wiped out as well in terms of
their terms reflect that. Their terms are often pretty onerous compared to traditional debt, because they look at it as it's a much riskier loan because they can't foreclose on the asset.
Right. All right. Is there anything else out there when people call you? What else are they asking you? What else did I not cover here?
I can think of some advice we're giving is basically to make sure they're communicating with their investors, and if they have to go down any of these capital call, preferred equity, sponsor loan roads, that they lay out the reasons why they're contemplating doing any of the above, and also what happens if they don't, what happens with the assets. So we always advocate lots of transparency and communication.
And just I don't know, something triggered when you said that is, do you guys represent LPs if there's an issue against the GP? Does that question make sense?
Yeah, I don't think we typically would.
Okay.
But I guess we would evaluate it sort of on a case-by-case basis.
Okay. So maybe it's not a GP that you worked with. So let's say an LP came to you and they said, look, I have a deal in Oklahoma or wherever it is. Would you guys, or it could be in Texas, but you didn't work on the deal as a GP. And they're looking at remedies for, maybe we have an issue on this deal and we're like trying to take it over or something like that. But
yeah, in that case, that would be something we would be much more likely to step in on. We just stepped in on a deal. I forgot where it was, but where the sponsorship team threw in pref-ec, a week before closing, and it, as I said, it materially changes the docs.
Right.
And we went basically line by line with this LP as to what everything meant in these docs. Maybe it scared him a little bit too much, but yeah, in that case, if we don't have any sort of relationship with the GP group, we're certainly more likely to take that on.
Okay. All right. Perfect. So you guys will be at the conference here in a month and a half or so. So I appreciate you guys sponsoring that and coming out. What is the best way for people to reach out to you if they have any questions or on acquisitions, capital calls, any of that? What's the best way for people to reach out to you guys?
Yeah, so we have a team email, team@kaliserlaw.com.
Okay.
I don't know if you can put it up there, but yeah, that's probably the easiest way. That goes to all of us, and we're very quick on responding.
And refis and sales, not just acquisitions or capital calls, basically anything from a transactional aspect that comes up on any of these deals, we can assist with.
And we don't just work in Texas, for offering documents, PPM documents, it's federal law, so we do that nationwide. And then there's many states that we can also do the entire transaction.
Okay. All right. Well, I always love seeing you guys in person and catching up and talking shop. So thanks for jumping on and doing this recording. And I'll see you in a couple weeks.
Yeah, we look forward to it.
Thanks for having us.
Thank you.
All right. See you guys.
Take care. Bye-bye.
Bye.